Okay, we are going to get our next session up and going here. For those of you that joined us late today, please know that you will receive a copy of today's and tomorrow's PowerPoint presentation, so you don't need to scramble and take copious notes. We'll get that to you by way of email. So our next segment this morning is going to focus on hot employment topics, ranging from protected classes to gig workers and more. And these are issues that all employers are currently dealing with in the workplace. So I'd like to welcome in Sean Monson and Liz Mellem. Sean Monson is a shareholder from the firm's Salt Lake City office and the chair of the firm's employment and labor practice. He focuses his practice in employment counseling and litigation and real estate litigation and transaction. And Liz Mellem is our Missoula office managing shareholder and concentrates her practice on a wide range of employment and labor law litigation, including sexual harassment and wrongful termination. So Liz, Sean, thank you both very much for joining us this morning. Liz, I want to start by asking one quick question that came up in Kevin's presentation just a moment ago, and it's related to Montana state law. And the question is this: with Montana's law that makes vaccination status a protected class, a lot of employers are feeling like their hands are completely bound. Does the CDC's ruling override Montana law, or should an employer wait for a suit to challenge the law? Thoughts on that?
So the question is about Montana's HB 702, which created a new protected class for vaccination status of individuals. It applies to all vaccines, not just COVID-19. And there are currently two cases in Montana that are challenging the law. One is a federal case based on healthcare workers, and the other is a state court case over in eastern Montana. Both are in their very early stages, so we don't know what the court rulings are going to be or where things are going to go. But as of right now, that is a valid Montana law, and it is supreme or better or the law over any ruling or guidance, but not a federal law generally. So it is a very tricky situation. There is not a specific yes or no answer. And what employers really need to do is do their best to basically navigate, competing interests and make sure that they are treating everyone the same regardless of their vaccination status. I am happy to talk to any Montana-based employer or employer with Montana employees more specifically about their factual situation to help guide them a little bit better. But unfortunately, there's not a clear, direct answer given the pending litigation and the fact that we are potentially going to get a rule, an actual rule from OSHA soon that might conflict with the Montana law.
Thank you very much, Liz. Appreciate you addressing that question. So I know you and Sean are going to co-present here. We've got a rapid fire session coming up, so hold on, audience, as Liz and Sean take you through our first session one of Hot Topics.
Thanks, Jason. As Jason said, my name is Sean Monson. I'm the chair of the Employment and Labor and Immigration Department of the firm. Before we start talking about kind of all the hot topics, I want to just kind of go through a real quick summary that I think is helpful for some folks to understand kind of the framework of the many kind of employment disputes that we deal with. One of the base rules in most states, except for Montana, is that employees are at will. And that means they can be fired at any time for any reason. And oftentimes when I'm dealing with clients that are talking about a potential termination, and we talk about the risks of that termination and whether ways to go forward or not, the question inevitably gets asked, well, aren't we an at-will state? Can't I fire them for any reason or no reason? And the answer to that question is yes, but there are caveats. And I want to just kind of quickly take 5 minutes maybe, just kind of give you the range of those caveats so that you have that as a resource when you're thinking about terminations in your workforce. If you imagine the at-will doctrine as being a big circle pie, you've seen those, a big circle pie graph. over time, and over time, that pie graph, there have been slices of the pie graph that have been taken out. So the first set of slices are federal and state anti-discrimination statutes. Those are things like the Title VII of the 1964 Civil Rights Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, the Genetic Information Act. These are essentially statutes. In the case of Title VII, involving an employee's race, national origin, color, religion, pregnancy. In the case of the ADA, an individual employee's disability, whether mental or physical. And in the case of the ADEA, an employee's age, in this case over 40. These statutes say that you can't take an adverse employment action, whether it's a suspension, demotion, cut in pay, or termination, because of their membership in the protected class, because of their race, national origin, disability, age, all those protected classes. You can't take an adverse employment action because of their membership in that class. And that's the key. It doesn't mean that you can't terminate someone who might be a member of a racial minority. Doesn't mean you can't terminate someone who is a member of a religious minority. Doesn't mean you can't terminate someone who is disabled. What it means is that you can't terminate them because of their disability, their age, or their religion. And that because of is the real key, because how these cases play out is the employee, if an employee is disabled, for example, and gets terminated, and then they can show that they were treated differently than other people who were not disabled in the termination process, then they have what's called a prima facie case of discrimination. And then, the burden will then shift to you as the employer to say, no, the reasons why we treated you differently, the reasons why we terminated you were in your termination were not because of your membership in a protected class, but were because of performance issues, attendance issues, whatever you might have. And obviously the key to that, and what I think is important for clients to understand, is that anytime you're making disciplinary actions that might lead to a termination decision, you need to make sure that it's in writing. And we're going to talk about this a little bit later, but if it's not in writing, it didn't happen. So make sure that any kind of disciplinary actions you put in writing, you put in this is what the issue was, so that you have a written record of it, because that written record is going to become your exhibits at trial if you end up going to trial. So that's one slice of the pie that's cut out of the at-will pie. Another slice out of the at-will pie is retaliation. And that is, you can't take an adverse employment action, a demotion, pay cut, termination, because that person has complained about discrimination or harassment, or because someone has participated in an investigation. So if Joe brings a claim that he's been sexually harassed by Bob, and Susie is a witness is a witness and provides testimony or provides information regarding the investigation, the employer can't take an adverse employment against Susie because of her participation in that investigation. So those are two big slices out of the at-will pie. Another slice is what we call at-will employment contracts. And you think about a contract, when you normally execute a contract, two people sit down, they have a document in writing, they both sign, and you have a contract. Contracts can also arise by, they can become implied contracts. And an implied contract, for example, is something like if you have an employee handbook, and your employee handbook might say, we don't terminate someone unless we give them a verbal warning, a written warning, and then a suspension, and then terminate. So essentially, an implied contract is a commitment by the employer to engage in certain behavior or to do certain things before an adverse employment action is taken. Progressive discipline is an example of an implied contract. And an implied contract can arise by written policies, handbooks, statements by a supervisor, either before or after the employee is hired. So for example, if an employee during an interview, the supervisor says, look, I promise you, as long as I work here, you're going to have a job. That would potentially create an implied contract that would supersede or alter the at-will relationship. And the last category of carve-outs under the at-will doctrine are what we call public policy decisions and public policy reasons, excuse me. And those are situations where an employee claims that they were terminated because they were exercising a legal right or privilege, such as they went to vote, and the employer didn't want them to go vote, and because it's going to be disruptive to the workday, and so that would be a potential, if the employee could show that they were terminated because they went to vote, then that would be a termination in violation of public policy. Or if they had to serve on a jury duty, and they had to serve on a jury duty for 3 weeks, and the employer said, "Hey, I can't handle you, be gone for 3 weeks. I'm just going to let you go." That would be a potential termination in violation of public policy. Or if the employee insisted on the employer complying with the law or refused to perform an illegal act, that would be another potential public termination in violation of public policy. So I wanted to just kind of take a few minutes to and just kind of give you that framework, that outline, because I think it helps you when you're thinking about termination decisions. You need to go through this checklist. Do we have someone who might have a potential discrimination claim? Do we have someone who has complained before, might have a retaliation claim? Do we have any kind of implied, in fact, contracts that might be working? And is there any reason to think that this termination might be in violation of public policy? That's the checklist I go through with employers, with my clients, before we do a termination, and I think it's helpful for you to have that information. Okay, next slide. Okay, Liz.
All right, let's dive into some of the hot topics we're going to talk about today. The first one, of course, is sexual harassment. This is still a hot topic. I think it's pretty much always going to be a hot topic, especially for employers. You have got to be prepared for this. It is becoming more and more of an issue in employment situations, and it's something that really, at this point, there's essentially no excuse for employers not to be aware of this and to be working to correct it or stop it in their workplace. So what is sexual harassment? There's a variety of different types of it, the most obvious of which is a quid pro quo, that you're going to get something in exchange for something. So a supervisor or someone with the ability to either negatively impact or positively impact an employee's work situation says, well, I will give you the better work schedule, or I'll give you a pay raise, or I'll let you have next Saturday off like you wanted if you go on a date with me, or if you have sex with me, or if XYZ. That would be what a quid pro quo is. Next slide, please. So hostile work environment, you may have heard employees or may hear generally employees say, oh, well, my boss is a jerk and it's a hostile work environment. Hostile work environment is really more of a term of art that relates to sexual harassment. And it is when there's sexual conduct or gender-based hostility that is either sufficiently severe enough or pervasive enough that it creates an intimidating, hostile, offensive environment. So that means it could be a bunch of tiny things over time that are pervasive enough to build into this, or it could be one really severe limited action that creates this environment. So additional examples of sexual harassment that you need to be aware of are sending suggestive letters or emails, displaying inappropriate sexual images or posters in the workplace. This one's a big deal if you have like cubicles or offices for your employers or your employees, or you have a space that's kind of theirs, in quotation marks, within your work area. You need to make sure that they are not posting anything that is considered inappropriate or offensive to others in the workplace. Additional examples are, telling lewd jokes or sharing sexual anecdotes, making inappropriate sexual gestures, which could be something as seemingly innocuous as a hug. But if you have people who are over huggers or kind of aggressive huggers, or even someone that just says, hey, I'm a huggy person, that's what I do, and another person is made uncomfortable by that, they are intimidated by that, or they are offended, that's a problem. So the inappropriate touching or purposefully making another person uncomfortable can also be a form of sexual harassment. In addition, there's, making comments about someone's appearance, their clothing, or their body parts. That's a big no-no. Next slide, please. So asking sexual questions or questions about someone's sexual history or their orientation, or making offensive comments about their gender identity or their sexual orientation. This could be, I've had a situation with a client where manager of a group of all men in the type of work they were doing would come in every Monday and ask people who got lucky that weekend. And that was an issue. He had to be, he had to be canceled about that, told it was inappropriate because it was making some of the male employees uncomfortable. And while it may be seen as, locker room talk or what's normal or any other type of statement to try to downplay it, in an employment context and a work environment, it's inappropriate. So now Sean's going to talk about the recent developments with LGBTQ discrimination and where we think that is headed and where it stands.
I just want to talk. Just kind of wanted to follow up on one thing that was said, and that is, you need to understand, and employers need to understand that sexual harassment does not have to be a male harassing a female or a female harassing a male. I was having a conversation with a client yesterday, and I was explaining to the client a situation that I dealt with where there was a claim that a female had harassed a male, and the client just could not get that in his mind that would actually happen. And this is kind of part of what I'm going to talk about with regard to the Supreme Court's decision. One of the things that is essentially impermissible is treating employees based on stereotypes. And we're going to talk a little bit more about that when we talk as we go through these slides on LGBTQ plus discrimination. So for many years, it was uncertain whether sexual orientation was a protected class under the gender prong of Title VII. And various circuit courts wrestled with that. And then in 2020, Supreme Court, in the decision of Bostock versus Clayton County, said that, kind of resolved the controversy among the different courts and said, yes, the gender prong of Title VII protects someone based on their sexual orientation or transgender status. And after that decision came down, Supreme Court decisions generally don't, they kind of make the rules, but they don't really necessarily flesh out the rules. And so after the Bostock decision, the EOC, which is the federal agency that essentially administers Title VII, came out with some guidelines about how are employers to structure and handle employees who are who might be gay or who might be transgender. So here's some of the guidance. We're going to talk about some of those guidelines that the EOC gave. First guideline is that you might have customers or clients who don't want to work with someone who's transgender and who don't want to work with someone because of their sexual orientation. That is not permissible. You're not allowed to fire or or discipline or hide those employees from the public because you think, what, my customers really don't want to deal with someone who's transgendered if you think that way, and you think your clients might think that way. That's impermissible. You cannot do that. You cannot, shield someone from being customer facing that otherwise would be in a customer facing position because of their transgender status or their sexual orientation. Next slide. You also cannot discriminate or treat employees differently because they don't conform to sex-based stereotypes. For example, if you have a male employee who acts in a way, acts like a female or has mannerisms like a female,
or vice versa. If you have a female who has mannerisms or acts in a way that you don't perceive would be the way a female should act, that's impermissible. You cannot treat them or treat them differently or engage in a discipline or terminate them because they don't conform to those sex stereotypes. Again, go along those lines. You can't require a transgendered employee to dress according to their sex assigned at birth. If they have elected to go through a transition, they are allowed to dress according to their identity status. The bathroom usage, again, is based on identity status, not on gender assigned at birth. And so if you have an employee who was born male but now identifies as female, they are allowed to use the female bathroom. That's why I think a lot of employers, and why I recommend a lot of my clients, if this becomes an issue, is to have unisex bathrooms. It solves some of these issues. At least have one unisex bathroom available, because you'll have conflicts where you have someone who has gone through a male who has gone through a transition to female, and there might be females in your workforce who are uncomfortable sharing a bathroom with that person, and vice versa. And one way to resolve that conflict is to have a unisex bathroom. This is the one that I found the most interesting, and I think this has been a very kind of, as I've seen more and more people identify their pronouns in their email signatures. This is becoming a much more prevalent issue recently, and that is misuse of someone's preferred pronoun can rise to the level of sexual harassment. So if you have someone who tells you or identifies for you either through an email signature line or through a conversation, their preferred pronouns are he and him, and it's someone who was a female at birth, and you say, I'm not gonna conform to that. You were a female at birth. I'm gonna call you she. I'm gonna say she and her when referring to you, and you do that persistently. That can rise at the level of sexual harassment. Now, the EEOC has said that occasional misuse or occasional mistakes in not using an employee's preferred pronoun will not rise to the level of sexual harassment, but persistent misuse of an employee's identified and requested pronouns can rise to the level of sexual harassment. So again, using him instead of her instead of him, or their and they instead of him or her, can rise to the level of sexual harassment if the employee has communicated that to you and you persistently don't follow their direction. Okay, next slide. I think this is now back to Liz.
Yeah, so what do you do if you get a complaint of sexual harassment, whether it's based on things that I was talking about or what Sean just mentioned? I'm going to quickly go through a couple of these slides to let you know, there are detailed steps about what you want to do at each point. And you will have, as Jason already mentioned, these slides sent to you so that you have them to keep for you. But I want to make sure that we save time so that we can get to independent contractors versus employees. First of all, if you get a sexual harassment complaint, respond to it. Do not ignore it. Do not push it aside, especially if there is any sort of history of this person making the same type of complaint. It needs to be taken seriously, all complaints. Explain the process to the person who is complaining and emphasize that retaliation is prohibited, as Sean mentioned at the very top of this hour. Set their expectation, that I'm going to look into this. This is going to take approximately X amount of time. And we will get to the bottom of this. You don't want to promise that there's going to be some sort of action taken, because maybe your investigation means no action should be taken, or maybe it does, but action that you didn't anticipate from the beginning. So don't make outright promises, but let them know you are going to be looking into it. The important thing is to show a willingness to believe and listen, and then you need to separate the alleged victim and the alleged harasser pending the investigation. So this may mean different shifts, it may mean administrative leave, it may mean different assigned duties for a limited period of time. You need to make sure, though, that in terms of the retaliation prong that is illegal, that you aren't doing something, for example, where you're giving the victim different shifts that result in less pay or worse working conditions, because while you may not intend that to be the situation, it can be seen as retaliation for a sexual harassment complaint. So you need to be very aware of that type of thing. We will always tell you to document everything. So this doesn't necessarily mean you have to have paper copies of things, but absolutely make sure you are putting electronic information and you are saving it and you are documenting what's happening. So first is to get the victim's story, ask them what happened, were there any witnesses, when did it happen? If you can get the victim to write up what their complaint is and give it to you, and then you interview them about their write-up, that's great because you have it in their words and it's not you writing it up after they've said it to you, which necessarily means that the words are coming out onto the piece of paper or onto the record through your lens. Then you go talk to the witnesses, get their stories, talk to them about, what they saw, what they've experienced, what they understand happened, or what their perception is, and make sure that they also sign a statement because you don't want their story to change either. Next slide, please. The next step, of course, is to confront or to interview the harasser. You want to make sure that they have an opportunity to respond to the allegations against him or her. And based on their response and all of the information that you've gathered, you then would make a decision about whether you believe that the victim has been subject to unlawful harassment, whose testimony is more credible, assuming, of course, that the alleged harasser is very likely not going to admit the behavior that he or she is accused of committing. And from there, you have to decide whether or not disciplinary action is appropriate. Next slide, please. With the disciplinary action, you want to make sure that if you take it, you document why you took the action, and you put that disciplinary action into the personnel file of the person who the discipline is against. You then also want your interview summaries and the other notes from your investigation to go in a completely separate file that's kept confidential and that is not tied to the personnel files of any of the individuals who are involved in your investigation. One thing to remember as well with this is that it does not have to be an internally conducted investigation. If you are not comfortable interviewing these people, asking these questions, making these determinations, you always can hire outside counsel or an outside investigator to take care of that process for you. It's something that both Sean and I have done repeatedly throughout our careers, that we go in as an outside observer, we interview the individuals, and then we help you, advise you as your legal counsel on what your next step should be based on the information gathered. We'll switch now to the difference between an independent contractor versus an employee. There is a lot of information in these coming slides, and we're probably going to skip some of it just in the interest of time. Do make sure that you go back and look at the slides once you receive them so that you understand the nuances here, because the big overall scheme or thing to remember about an independent contractor versus an employee is it is a different situation depending on the context that you are in. Historically, it boiled down to whether or not you had the right to control how that person did their work. But Sean is going to walk us through how that historic delineation is changing now and what you need to be aware of as an employer if you're choosing to contract with independent contractors.
Before I do that, I just want to kind of follow up on a couple of things that was said I just want to kind of add some more flesh to the bones, as it were, on a couple of the comments you said. One of the things in the slide that you'll notice that was talked about was having the
victim sign a statement. And I started doing that and telling my clients to do that about 5 or 6 years ago after a case. And I'll just kind of give you the brief aspects of the case. It's a company that you would all know if I told you who it was. It's a well-known company in Utah and in the Intermountain West, and they're essentially a fast casual restaurant. And how the case began was there was a young woman who was working at the cash register who came to the manager and said, "Hey, that cook back there, he cracked my back a couple nights ago." Now, what really, what does that mean? No one really knows. And the manager essentially said, "Okay, so he cracked her back." So the manager kind of wrote his notes down, went to the cook and said, "Hey, cook, don't crack her back anymore." The victim, or the alleged victim, after making that complaint, the next couple of weeks just was not performing well, was coming in coming in late, not dressing appropriately, just not doing her job well. And so they terminated her. And all the record we had, the only documentation we had was a complaint, and it wasn't even signed by her. It was just the manager's note saying the cook cracked my back. And then the other piece of documentation that we had was the manager going to the cook and saying, "I told him don't crack her back." So they fired this young woman, and and the young woman claimed that and the young woman, then after she was terminated, the story changed. And the story changed to one of the cook sexually assaulted me in the bathroom. And I have never been sexually active. It's part of my religious identity not to be sexually active. And he essentially raped me in the bathroom. So that was that obviously changed the dynamics of the case significantly. And after that experience, I told clients, you have got to make sure that when someone comes in and reports sexual harassment, and by the way, the information we talked about that Liz went over regarding investigations of sexual harassment, these rules regarding sexual harassment, those apply to all protected classes, because unlawful harassment just is not limited to gender or sex. You can have an unlawful harassment claim based on age, disability, national origin. So those rules apply to all the protected classes. But the point that I tell clients now is whenever you have a complaint of unlawful harassment, you need to make sure that somehow, some way, either as Liz said, and I think the best way is to have the victim write out what happened, or the alleged victim write out what happened to him or her. The other way to do it is if you're going to interview them, when you interview them, tell them you're going to be recording it. If that's a possibility, that's another way to do it. Probably the least effective way, but still it's better than doing nothing, is having the interview, then you typing up the summary of the interview, and then going to the alleged victim and saying, "Okay, is there anything else, or does this accurately reflect what happened?" But use one of those three methods, but you have got to get the alleged victim to commit to their story. Otherwise, it could change. It could change in a dramatic way that can really alter potential liability exposure of the employer. Because the employer, you do one thing and you take one certain set of steps. If the complaint is he cracked my back, it's a whole, obviously, and I'm saying the obvious, it's a whole different ball game if the allegation is I was sexually assaulted in a bathroom. So that's one point. I just want to really highlight that and make sure that that point is driven home on this.
I want to jump in real quick, Sean. We did have a question on the side about recommending sexual harassment trainers in the Utah area. Any of us at Parsons in our employment department can help with that. We conduct sexual harassment trainings regularly. it's something we recommend to all of our clients to do at least on an annual basis. And there are different types of trainings for your management level employees and then for your basic level employees. And you can reach out to either Sean or I. We're both licensed in Utah, or anyone else in our Salt Lake office to help with that.
Yeah, Liz is right. We do this kind of stuff all the time. And then the other thing I wanted to touch base on is Liz talked about the fact that we also, if you're not comfortable doing an investigation, to hire outside counsel, and whether it's us, whether it's independent investigator, I would often recommend that. And the reason why is because, Liz talked about the questions you need to be, those slides talked about the questions you need to be asking. Essentially, what those slides are giving you instruction on is what we as lawyers do when we interview a witness in a formal setting, either in a deposition or in court. We're asking questions: who said what or did what? When did they do it? Where did they do it? Who else was there? And we do this all the time, and so we're very comfortable with that process. And the advantage I think that you have by having an outside law firm or an outside investigator doing your investigation is A, there is no perception generally of bias or favoritism, and B, you're going to make sure that you have a complete investigation. I'm dealing with a case right now where the investigation was not well done. There was people who should have been talked to, but were not talked to, and the reason why is because they said, well, we don't want to bother them, or whatever the reasons were. There's various different reasons. Because the investigation was not done correctly, it's causing a lot of problems on the back end for me when I'm now defending a claim of sexual harassment. And one of the things I have to deal with is a claim that the investigation was not properly done. So those are just a couple of things just to kind of wrap up the sexual harassment component or part of this. All right, so as Liz talked about the independent contractor versus employee, and I think Liz is exactly right. The biggest takeaway from this is that, well, not the biggest takeaway, one of the big takeaways from this is that you need to understand that the issue of whether an employee or a worker, is classified as an employee or an independent contractor really depends on the context. Because there are different tests under federal law and state law. And even within federal law, there are different tests between various different federal statutes, such as the IRS standards regarding whether workers are employees or independent contractors for purposes of taxes. There's Fair Labor Standards Test, which is different. That's the statute that talks about overtime and child labor. Title VII, ADEA and ADA, different tests. So on the federal level, within the different federal statute, there are different tests that courts will use to decide whether someone is an employee or an independent contractor. Those tests then are different from the state law tests, and each state will have its own tests. And even within the state level, the tests are different between whether someone is independent contractor for purposes of unemployment compensation, or whether someone is an independent contractor employee for purposes of workers' compensation. So you can have a matrix of an employee where, for some circumstances, under some tests, under some statutes, they are an employee, and under some statutes, they are an independent contractor. So when you're thinking about classification issues, I really recommend that you talk to someone who does employment law to help you navigate all those different tests to make sure that this person, if you're going to classify them as independent contractor, they are properly classified under all the various tests. Because if you misclassify, then there are some pretty serious consequences. There can be penalties. There can be back pay under the Fair Labor Standards Act. There's some pretty serious consequences if you misclassify. And it's obviously very tempting to classify a worker as an independent contractor. You avoid FICA. You don't avoid it, but you have the employee pay part of their FICA, and you don't have to pay a workers' compensation. You have to pay unemployment compensation. So there's all those tempting things to hire someone as an independent contractor. Again, they have to pay all their own taxes. They have to pay all their own FICA. You don't have to pay their workers' compensation premiums. You don't have to pay their unemployment insurance premiums. But if you misclassify them, the penalties can be severe. Okay, So let's, we talked about that. Let's skip, if you would, Jason. I know that we're kind of bumping up. Let's skip to slide 72. There we go. Okay, and so this is kind of the beginning of this analysis, and the start of this analysis, the IRS 20-factor test. And the IRS 20-factor test is no longer used, but a lot of these elements are used both in all the different federal statutes, the tests under them, as well as under the different state statutes. A lot of these elements pop up, not all of them, and some of them are emphasized more than others, but this is kind of the benchmark of where you see a lot of the factors come out of. So the things the courts will look at is, was the employee given instructions? Was the employee given training? If the employee was given instructions, told what to do, then they're more likely to be an employee than an independent contractor. Is the work that the worker is doing integrated to the operations of the employer? And we're going to talk more about that later on, so we'll talk in more detail what that means. And these other tests that you see in this, all 20 of them, are all factors that the courts will look at potentially, or some of them, under the various tests under the federal statutes or the state statutes. Hey, Jason, could you skip to slide 76? Okay. So under the FLSA, which is the Fair Labor Standards Act, which governs overtime and minimum wage, the Department of Labor, the Wage and Hour Division, issued some guidance regarding this, and essentially the guidance was, we're going to look at the economic realities of whether the employer is employing an employee or independent contractor. And what that economic realities means is that, is the employee, or is the worker, dependent on the company, or do they have the ability to, if the company were to essentially say, we don't want you working for us anymore, would the worker have other sources of income? Essentially, does the worker provide the services that they're providing to the company to other people? That's what the Department of Labor essentially said in 2015 is going to be kind of the main guidance that they're going to be using, or the main test they're going to be using in deciding whether someone is an employee or independent contractor. Okay, let's go to the next slide. So again, the economic reality of the worker's relationship with the employer determines whether the worker is economically dependent on the employer and therefore an employee, or is in business for himself or herself and therefore an independent contractor. And that is kind of what you're seeing, the trend line, both in various federal statutes and in cases interpreting various federal statutes, and in the various states that are addressing this issue under workers' compensation and unemployment insurance. Okay, next slide. Again, no single factor is determinative. It's just whether the totality of the circumstances indicates that the worker is an employee or an independent contractor. Next slide. And so these are some of the following factors that they will look at and determine that economic reality test. Is the worker an integral part of the employer's business? Does the worker's managerial skill affect his or her opportunity for profit and loss? The relative investment of the worker and the employer, the worker's skill and initiative, the permanency of the worker's relationship with the employer's control of the employment relationship. Again, these are some of the factors that the Department of Labor and the courts will look at in determining whether someone is an independent contractor or an employee under the Fair Labor Standards Act. Okay, Jason, maybe skip a bunch of slides in 92. And as Liz said, we wanted to put the information in these slides so that you have the information. There's a lot of detail about what goes into these various tests, but we want to kind of highlight just a few of these slides at the end. So let's,
Hey, Sean, before you jump into gig economy, we have a question about if we are working with a contractor, maybe a translator, should we ask or require that they also work for other companies or businesses?
I would say, if you want to be safe, yes. I mean, I think the safest, and that is, I mean, and this is under Utah law, for Utah workers' compensation, for Utah, under the unemployment insurance rules, if someone gets fired and they claim unemployment insurance, Whether they have their own established business is going to be a key factor. It's also, it's a very, very important factor under Utah law. I mean, it's just positive. And it's also an important factor under the various tests. So if someone is only working for you as a interpreter, they're likely going to be considered an employee, even though you don't do any even though you didn't do any training, you don't tell them how to do their job. If you're the only company they're working for, they're likely to be considered to be an employee. It's certainly under Utah's unemployment statutory scheme and under other various federal statutes are likely to be included to be an employee. Okay. So gig economy workers. So this is becoming a huge issue, and the gig economy is obviously people like the people that work for DoorDash, Lyft, Uber. There's various services where essentially the idea is that there is a company that creates a website, and there are workers that have access to the work site, and there are people who need services done that have access to the website, and those workers and those people who need services find each other through the website. Now you think about Lyft or Uber, you need a ride, so you access the application. A driver who also has access to the application shows up and drives you. And so the issue of whether these people are independent contractors or employees, courts are really wrestling with this. And we haven't gotten, the final determinative guidance, but we've got some hints and some suggestions about how this is going to work out. Next slide. So the first thing to look at that is relevant to this is in 2018, the Department of Labor did a field assistance bulletin. The field assistant bulletin was not necessarily related to gig workers, but the guidance in this field assistant bulletin is instructive. So in the field assistance bulletin, they were looking at the issue of whether a staffing agency that essentially is a registry for home care nurses or caregivers. So essentially someone who's a home care nurse or a nursing home worker can register with this company, and then this company then helps them find or places them with nursing homes or home health care opportunities. Next slide. And so essentially the Department of Labor said, in these instances, the registry is generally not going to be considered to be the employer of the home health care nurses, because all the registry is doing is essentially acting as a recruiting agency that is finding these workers for its clients, the nursing homes and the home health people who need home health care. Okay, so unless the registry is controlling the terms and conditions, telling them how to do their job, telling them when they have to show up and those types of things, setting the rate of pay. But if they're not doing those things, then those workers are not going to be considered to be employees or independent contractors, because all the registry is doing is helping those workers find employment opportunities. But the nurses are setting their own rates of pay. They're essentially setting their own hours. They're not following any directions from the registry. So that bulletin said, generally, these type of registries are not going to be considered to be employers of the workers. Next slide. Okay, let's just go to the next slide. Okay, so that's generally what that bulletin said. Well, how does this apply to gig economy workers? Again, it's not exactly the same, but it's analogous. So in 2019, under the Trump administration, the Department of Labor issued an opinion letter talking about a virtual platform, talking about gig workers. And so essentially the question that the 2019 opinion letter addressed was whether service providers working for a virtual marketplace company are employees or independent contractors under the FLSA. So, they didn't state the name of the company, but imagine someone like Uber or Lyft being the company in this situation, or DoorDash. Next slide. So in the 2019 letter, the Department of Labor just concluded that the virtual platform, the Uber, the Lyft, the DoorDash, or whoever this company was, again, they didn't name the company because they don't do that in opinion letters. Whoever that company was, they were not the employer of the gig workers, and all they were doing was providing a referral service. They had workers who wanted to work. They had there were other people who needed those services, and all this platform was doing was essentially marrying up the workers to the people who needed services. Next slide. And these are part of the reasons why. This is some of the reasoning why the Department of Labor concluded that, because they were free to work when, where, and how for whom they wanted, and they were free to work for competitors of the virtual marketplace company. They could exit the virtual marketplace when they chose and had the ability to negotiate the prices paid by the consumer, so they could hop onto the network. They could work for who they wanted, when they wanted. They could set their own rates of compensation. And because of those factors, the Department of Labor said they are independent contractors, not workers. Okay. The Biden administration then came in on May 5th, 2021. They withdrew that opinion. Okay. So essentially, they withdrew that opinion because there was another rule that had been issued that they withdrew as well. So we had the Trump administration essentially wanting to say that workers in that the virtual marketplace, the Uber, the Lyft, the DoorDash, is only a referral service. It's not the employer of the workers who are providing services. The Biden administration came in and essentially withdrew that opinion letter. And there's been a number of cases that have been circulating throughout federal and state courts throughout the United States with regard to these companies, Uber, Lyft, and DoorDash. And there really hasn't been any case that has yet gone through a trial or an appeal to where we have a final decision. But there have been a couple of cases, and they're in the slides. I'll just talk about them. We don't have time to go to them. There's been a couple of cases that have been decided that haven't got to the final issue, but have got to some preliminary issues. And in those two cases, there's really been two cases that have addressed substantively the issue of, are these people, and it was for Uber, one was for Uber, one was for Lyft. Are the workers who work with the drivers for Uber and Lyft, are they employees or are they independent contractors? Uber and Lyft have said, we're technology companies. We create software, and then people use our software. Drivers use our software to find riders. Riders use our software to find drivers. And the two courts that have addressed this issue substantively, one's out of California, one's out of Massachusetts, have said, no, you're not. You are a transportation company, because this is integral. What these people are doing is integral to your business. Your business is providing rides, and these people the workers are just the fulfillment of that, and so they are integral to your business, so they are workers. So the takeaway from this, to me, is A, it's unsettled. B, the rules can change with the changes in administration. And so that's much more prevalent now, where with the change of presidential administrations, the Department of Labor's guidance changes quite a bit more than it used to be. In the past, when you had changes in administration, the Department of Labor still had some consistency, still had some stability. It seems to be changing more frequently. Their guidance is changing more frequently with the change in administration than it used to be. And the final takeaway is that if you are hiring someone as independent contractor, there's two things that can really be a problem for you. One is if they are providing, is if what the service that independent contractor is providing is integral to what your business is. You know, if you are a software company and you are hiring software engineers, that's an integral part of your business. If you're a software company and you're hiring a janitor, what the janitor is doing is not integral to your business. So whether the worker is doing something that's integral to your business is a key component. The other key component that you need to think about is the worker providing this service to someone else? You know, there's all these factors, all these tests, and you can go through those slides and you can see them. But that's really kind of the two core issues that we're seeing starting to develop in states and in federal courts about whether people are independent contractors or whether they're employees under federal statutes and state statutes. Okay, is there any questions?
Yeah, Sean, following up on the question before about, whether or not a contractor works for another company, should the company, the original company, be checking on that? Like on a yearly basis, should they be having that contractor kind of certify or state that they are working for other individuals?
Yeah, I mean,
Or should they make it part of their contract from the beginning that they have to work for other companies?
yeah, what we recommended with the client we did this recently is that the worker provide evidence every 2 years of like advertisements, websites, Instagram, Facebook ads where they're advertising their services to other people.
Okay, every
And
2 years?
every 2 years. I mean, you know, that's not there's nothing magical in that. That was just something that we kind of negotiated with the client that the client wanted to do. I mean, you could do it every year. But the point is you need to be, you know, I would really recommend that you be upfront about this, that particularly if someone's doing something that's integral to your business, that you make sure that they are working for other people. They provide you evidence that they're working for other people. Yeah.
Well, Sean and Liz, great presentation. Thank you both very much for your time and your insights. If you have questions for either Sean or Liz, please feel free to contact them directly. Their contact information is on the screen. I'll leave it there for a moment. We'll take another break and we'll kick off our next presentation at the top of the hour at 10 a.m. And we're going to talk about political speech in the workplace. So we'll see you in about 4 minutes.
Thank you.